Hi, this is Ed Sullivan and Mark O'Berdy of O'Berdy Sullivan. Mark is an expert on non-compete laws here in the state of Texas. And the question I have today, Mark, is what happens when an employer suspects an executive or somebody with a non-compete of violating that non-compete? What can they actually do?
Well, a lot of times they'll start out sending a very mean-spirited sounding letter to the ex-employee, and oftentimes the new company, demanding a series of sworn statements or representations, of what the person's doing and that they're not competing. And of course, a lot of times the new employee and the new company blow that off, or they don't provide that sort of information. And if it's not resolved at that point, well, then the next step is the former employer can file a lawsuit. And a lot of times, unlike a normal lawsuit that's just, we're suing for money and the suit goes on for years, what they do is they file what's called a request for an injunction, a temporary restraining order and a temporary injunction, where they actually ask the court, enter an order to stop this person from competing against us. And that can move very fast and very quick. It can be very expensive. And so if you get into one of these wars, you need to have top flight attorneys, experts representing you. And even better advice, frankly, is before you go down this road of leaving your company and joining a competitor when you've got a non-compete, talk to experienced board-certified labor and employment lawyers who practice in this area heavily, and they oftentimes can help you navigate the situation to where you're going to avoid litigation in the first place, which is, of course, what it's all about.